Hello everyone, this is Shilpi Tyagi, Assistant Professor at IIMT College of Law. Today I'm going to discuss topic right to free legal aid. As we all know that this is the burning topic of the today's change scenario. We start this with the statement of Justice Blackman. The concept of seeking justice cannot be equated with the value of dollars. Money plays no role in seeking justice. Let's start with the introduction. Legal aid plays a crucial role in enabling access to justice for the poor and needy. Legal aid refers to providing free legal services to individuals who cannot afford the services of a lawyer for their legal proceedings in courts or before judicial authorities. It aims to ensure that everyone has access to justice regardless of their financial situation. When we talk about the concept of justice, we see the concept of justice in the preamble of the Indian Constitution. The preamble of the Indian Constitution emphasizes securing justice for the people of India, both in socio economic and political aspects. Justice P.N. Bhagwati has described legal aid as a system that ensures easy access to the administration of justice for those who need it to enforce their legal rights. When we talk about the Indian Constitution commitment to justice is evident in several ways, including preamble. The preamble's opening lines state that one of the Constitution's most important purposes is to secure justice for all citizens, including social, economic and political justice. preamble में इन तीनों तरीके के जस्टिस की बात की गई है, सोशल, इकोनॉमिक एंड पॉलिटिकल जस्टिस. Next is Article 14, 15, 16 and 17. These articles also talk about the concept of justice. Article 39A. This article includes provisions for equal justice and free legal aid. It also states that the legal system should promote justice based on equal opportunity. Article 38 and 39. These articles define distributive justice, which is the fair distribution of resources to those who are needy, to those in need. Article 142. This article allows the Supreme Court to pass orders or decrees to ensure complete justice in any matter or court pending before it. What is right to free legal aid? Now we will see that what is right to free legal aid. Legal aid क्या है? The right to free legal aid refers to the entitlement of individuals who cannot afford legal services to receive legal assistance and representation at no cost. It is fundamental right aimed at ensuring equal access to justice for all, regardless of economic or social disparities. The right to free legal aid is recognized and protected by various legal frameworks and constitutional provisions in many countries. फ्री लीगल एड का जो कंसेप्ट हम देखते हैं वो हम कॉन्स्टिट्यूशन में भी मिलता है हमें. हम यूडीएचआर की बात करें तो वहां पे भी मिलता है हमें. और ये इसके रिगार्डिंग अलग इंस्टीट्यूट भी हैं जैसे लीगल सर्विसेज अथॉरिटीज एक्ट. The essence of the right to free legal aid lies in the principle that justice should not be restricted to those who cannot afford legal representation. It acknowledges that individuals facing legal proceedings, particularly those from marginalized and disadvantaged backgrounds, may be unable to navigate the legal system effectively without professional assistance. Under the right to free legal aid, the eligible individuals are provided with legal services including advice, consultation, and representation, either fully funded by the government or through legal aid organizations. These services extend to various stages of legal proceedings, such as criminal trials, civil disputes, and administrative hearings. When we talk about the history of free legal aid in India, then we see the Law Commission of India stated in its report on reform of judicial administration published in 1958 that providing legal assistance to destitute litigants is a fundamental issue, not a minor procedural issue. The government drew some lines for legal aid schemes in 1960. In the year 1976, in 42nd Amendment that was initiated which incorporated Article 39A. Under the chairmanship of Honorable Justice P.N. Bhagwati, a committee for implementing legal aid schemes was formed in 1980 to oversee and supervise legal aid projects. The Legal Services Authorities Act was established in 1987 to provide a formal framework and a standardized structure for legal help schemes across the country. On 5th December 1995, the National Legal Services Authority was established as a statutory body to formulate policies and guidelines for providing legal assistance in accordance with statutory provisions as well as to develop the most efficient and cost effective legal services schemes. Now we see legal aid in India. The Indian Constitution's preamble seeks to provide the people of India with fairness, both socio-economic and political. The Indian Constitution's Article 38 and 39A are noteworthy. Article 38 states that the state shall promote the welfare of the people by securing and protecting the social order, including justice. And Article 39A states that the state shall in particular provide free legal aid through appropriate legislation or schemes to ensure that no citizen's opportunities for securing justice are denied. When the Legal Service Authorities Act went into force in 1995, it made free legal services available throughout India to people who are socially, economically poor. One of the key components of the legislation which seeks to provide equal access to justice for all mandates pro bono attorneys and advocates to give their services free of charge to those who cannot afford it. In practice, however, it is extremely difficult preventing it from reaching its full potential and denying the poor access to high quality justice. In order to maintain the rule of law in a democratic society, everyone, especially the poor, marginalized communities, and disadvantaged, must have access to justice. The state shall guarantee that all people are treated equally before the law and have access to a judicial system that maintains justice based on fairness, according to Article 14 of the Indian Constitution. In 1976, the Indian Parliament incorporated Article 39A of the Constitution, which established free legal assistance as a basic principle. Some other legislations which enacted in favor of legal aid is discussed as the Bar Council of India Legal Aid Rules 1983, Legal Practitioners Bill 2010. Now we see some judicial pronouncements regarding the development of right to free legal aid. In the case of Husnara Khatun versus State of Bihar, it was established that if an accused person cannot afford legal services, they have the right to free legal aid provided by the state. This ensures that everyone can access legal representation regardless of their financial situation. Rights of the accused and legal aid. Under Section 304 of the CRPC, if an accused person does not have sufficient means to hire a lawyer, the court must appoint one for their defense at the expense of the state. This ensures that the accused receives proper legal representation. In CPC also, we see the concept of legal aid which is provided under Order 33. The obligation to provide legal aid arises from the moment that the accused is presented before the magistrate for the first time and continues throughout the proceedings as established in the case of Khatri versus State of Bihar. In cases where a person is entitled to appeal against their sentence, they have the right to request legal counsel to prepare and present the appeal as per M.H. Hoskert versus State of Maharashtra. Role of police and judiciary. The police are responsible for immediately informing the nearest legal aid committee when a person is arrested, as stated in the case of Sheila versus State of Maharashtra. This ensures that the arrested individual's right to legal aid is protected from the outset. Why legal aid? Legal aid Legal aid to the poor and weak is necessary for the preservation of the rule of law, which is necessary for the existence of the orderly society. Until and unless poor, illiterate man is not legally assisted, he is denied equality in the opportunity to seek justice. Therefore, as a step towards making the legal service serve the poor and the deprived, the judiciary has taken active interest in providing legal aid to the needy. Institutions providing free legal services. There are several institutions at different levels. Those are responsible for providing free legal services as national level, National Legal Services Authority, NALSA, established under the Legal Service Authorities Act 1987. The Chief Justice of India serves as in patron-in-chief. At the state level, the State Legal Service Authority, headed by the Chief Justice of State High Court, who acts as its patron-in-chief. District level, District Legal Services Authority, the District Judge of the district serves as its ex-officio chairman. Taluka subdivision level, Taluka Sub-Divisional Legal Services Committee led by Senior Civil Judge, High Court Legal Service Committee, Supreme Court Legal Services Committee. Now we will see that what is the eligibility criteria for free legal aid, which is provided under Section 12 of Legal Services Authorities Act, which include members of scheduled castes, scheduled tribes, victim of human trafficking or beggars, women or children, persons with disabilities as defined in the Persons with Disabilities Act 1995. Individuals in custody, including those in protective homes. In cases before the Supreme Court, individuals with an annual income of less than rupees 5 lakh, and for cases before other courts, individuals meeting the income criteria prescribed by the state government. Scope. What is the scope for free legal aid? Legal aid services provided under free legal aid cover a range of assistance as according to Section 2, Clause C of the Legal Services Authorities Act 1987. Legal services include services related to any case or legal proceeding before a court, authority, or tribunal, as well as advice on legal matters. Some examples of legal assistance covered under free legal aid are representation by an advocate in legal proceedings, payment of process fees, witness expenses, and other charges associated with legal proceedings, preparation of pleadings, appeals, paper books, including document translation and printing, drafting legal documents, and special leave petitions, providing advice on legal matters. These services aim to ensure that individuals who are eligible for free legal aid receive the necessary support and guidance to navigate the legal process. There are some cases which are excluded from legal aid. These are defamation, malicious prosecution, contempt of court, election proceedings, fine imposed up to rupees 50, economic offences and social loss, lack of direct concern. Issues and challenges in free legal aid. Lack of public legal education and awareness. One major obstacle is the poor and illiterate population. Lack of legal education and awareness. Many people are unaware of their basic rights and the legal aid services available to them. This lack of awareness hampers the goal of the legal aid movement as people are unfamiliar with initiatives like Lok Adalats and legal aid. Lack of support from advocates and lawyers. Many advocates and lawyers prioritize receiving proper fees for their services. Only a few actively participate in social service programs like legal aid. Limited powers of Lok Adalat. Limited Lok adalats, though designed to provide alternative dispute resolution, have limited powers compared to civil court. They often face challenges related to procedural limitations and the inability to compel parties to appear for proceedings. Non-appearance of one party can lead to delays in case disposal. Underutilization of paralegal volunteers. Paralegal volunteers play a crucial role in promoting legal aid camps and schemes and reaching out to marginalized sections of society. However, there is a lack of proper training, monitoring, and verification of these volunteers. Additionally, the number of available paralegal volunteers is insufficient to cater to the entire population's needs. Awareness of legal aid is still a challenge. This is still a challenge. One of the cause of weak institutional system is the lack of awareness of the presence of such legal help. The accused individual is frequently unaware of their entitlement to legal representation. Another key problem is the perception that such a free legal service is of poor quality. The legal service authorities do not have enough attorneys, and even if some are appointed, they cannot afford to provide effective assistance. And there are some other lacunas which we find regarding legal aid service. Lawyers do not participate in pro bono work for a variety of reasons, financial resources. Earlier, legal education did not include social education. As a result, they do not comprehend or embrace their role, and members of the profession do not often interact with people of the community who require legal aid. Illiteracy is another significant barrier to legal help. In the last, we come to the conclusion legal aid is a crucial component of India's legal system, aiming to provide equal access to justice and protect the rights of all citizens, especially those who are economically disadvantaged. The legal aid system plays a vital role in upholding the rule of law and ensuring justice for all. In the last, I will say that recently Justice UU Lalit also said regarding the poor quality of legal aid. He said that we need not poor legal aid. Uh, Legal aid means legal aid to poor people. Thank you.